Imagine you have a law, an ancient legal shield, forged over centuries to protect the innocent. Now imagine a scientific test so powerful that it feels like a sword of truth, capable of cutting through any lie. So what happens when that unstoppable sword meets that unbreakable shield right in the middle of a courtroom? Well, that is not a riddle. That is the exact high-stakes question India's Supreme Court had to answer in a case that could redefine truth itself. And look, this is not some movie plot. This is a real-life gut punch. What do you do when a DNA report gives you undeniable scientific proof that you are not a child's father, but a law that is more than a century old says, too bad you are? The stakes here are astronomical. We are talking about a child's future, a man's rights, and the very definition of what is real in our legal system. Before we peel back the layers of this landmark Supreme Court standoff, hit that subscribe button for KanoonPlus, where we give you the real story behind the headlines, grounded in facts, without the boring lectures. You are not going to want to miss what is coming. Okay, here is our game plan. First, we are going to lay out the core dilemma. Then, we will dive into the human story that started this whole firestorm. After that, it is the main event, the clash between law and science. Then, we will reveal the Supreme Court's game-changing verdict. And finally, we will unpack what it all means for truth, liberty, and a child's welfare. Let's do this. Alright, let's kick things off with Section 1, the DNA dilemma. And look, this is not just about some abstract legal argument. At the heart of this entire legal showdown are two people, Nikhat Parveen and Rafique. Their very personal, very messy conflict ended up asking a question so huge that it shook the foundations of Indian family law. You know, every one of these massive landmark cases always starts small, does it not? They start with a human story, a marriage that falls apart, a child stuck in the middle, and a nasty fight over responsibility. It is these raw, real-life dramas that force our entire legal system to look in the mirror and ask the toughest questions. Which brings us right to the heart of it in Section 2. A marriage, a child, a test. This is the story of Nikhat Parveen versus Rafique, and it is where all that legal theory gets a serious dose of reality. Whoa. Okay, just look at this timeline. It tells a wild story. They get married on March 2. A child is born less than a month later, on April 1. By July, everything has exploded. Nikhat files for maintenance, and Rafique's response is basically a legal grenade. He denies that he is the father and demands a DNA test. That test happens in 2017, but the final word from the Supreme Court does not come until 2024. That is 7 years of legal and emotional limbo. Just imagine. So the case starts its journey on this judicial seesaw. First, the trial court looks at the DNA report, which is crystal clear that Rafique is not the biological father, and says, case closed, no maintenance. Then it goes to the first appellate court. They agree completely. Then it lands before the Delhi High Court. And the High Court says, look, we understand the old legal presumption, but you cannot ignore a hard scientific fact that nobody is even questioning. At every single step, science is winning. But this was far from over. And this sets up the main event, the clash of the titans in Section 3, law's shield versus science's sword. This is it. You have an ancient legal tradition designed to protect children on one side, and the sharp, cold, undeniable truth of modern genetics on the other. So let's really break down these two opposing forces. First, you have the shield, Section 112 of the Indian Evidence Act. It is basically an ironclad rule that says, if a child is born while a couple is married, it is conclusive proof that the husband is the father. The goal was to protect children from the terrible stigma of being called illegitimate. But then you have the sword, the DNA report. This is not a presumption. It is not a legal fiction. It is scientific proof. It is objective reality. And in this case, that reality was undisputed. So which one wins? I mean, just listen to that legal language. Conclusive proof. In the world of law, that is like a brick wall. It is the law literally telling a judge, stop, end of discussion, do not look any further. For more than 100 years, this rule was practically untouchable, all in the name of protecting a child's dignity. And here you can see the thinking behind that shield. This quote from an older case, Dukta Jahan, really shows how much courts dreaded this issue. They were terrified of any ruling that would brand a child with a horrible label or shame the mother. The law was built to be a fortress against that kind of social harm. But then science kicked the door down. In 2014, in a case called Nandlal Badwaik, the Supreme Court dropped an absolute bombshell. It said that when there is a direct clash between an old legal presumption and modern scientific proof, science has to win. The court basically asked, why on earth would we rely on a presumption when we have the actual, undeniable truth right in front of us? This was an earthquake. But just when you think the path is clear, the legal world throws a massive curveball. In a 2024 case, Aparna Firodia, a different set of Supreme Court judges, said the complete opposite. They said that even if a DNA test proves the husband is not the father, the old law is irrebuttable. So wait, what? We now have two top-level Supreme Court rulings that are in total conflict. How can that be? And that massive contradiction sets the stage perfectly for our climax in Section 4. The Supreme Court's verdict. The court was not just deciding the fate of Nikhat Parveen and Rafique, it had to step in and clean up this huge legal mess that it had itself created. So how did the court solve this puzzle? By zeroing in on one simple but incredibly powerful fact. In many of those previous fights, the argument was about whether to even order a DNA test. But in this case, that ship had already sailed. The test was done. The mother had agreed to it. And the most important part? Nobody was arguing with the results. The scientific truth was already on the table, a done deal. And that key distinction led the court to lay down this powerful new rule. When a DNA test is done, consented to, undisputed, and it directly contradicts the old legal presumption, the scientific truth must prevail. Think of it this way. A presumption is a map you use when you are lost. But if someone hands you a GPS with your exact location, you throw the map away. The proof has to beat the presumption. So, the court's logic here was beautifully simple. The test was already a fact on the record. The mother had consented, so no one was being forced. Everyone accepted the result. It was final. So the court said this case fits perfectly with the logic from the Badwaik decision. There is zero need to presume anything when you already know the truth. But the story does not end with just a legal ruling. And that brings us to our final section. Truth, liberty, and welfare. Because the court understood something really important. Its decision was going to have a massive impact on the life of a real child. And this, for me, is where the judgment becomes truly remarkable. So the court made the legally correct call. The man, proven not to be the father, does not have to pay maintenance. But the court did not just stop there and close the case file. What it did next showed a kind of compassion and forward thinking that goes beyond the letter of the law. Instead of leaving this child in a legal gray area, the Supreme Court issued a direct order to the government. It said, "You will send an experienced official to the child's home. You will find out if this child is okay. Does the child have enough food? Is the child in school? Is the child healthy? And if the answer to any of those questions is no, the government must step in and fix it." The court acted as a true guardian. So let's boil this entire landmark case down to the key takeaways. 1. Undisputed scientific fact can now defeat a legal fiction. 2. Section 112 is still alive, but it is no longer an absolute, unbreakable rule. 3. Courts are still going to be extremely careful about ordering DNA tests. 4. Perhaps most importantly, the state now has a clear duty to step in and protect a child's welfare when the law leaves the child vulnerable. This all leads to the big question I want to ask you. The Supreme Court drew a new line in the sand, but the debate is far from over. Should our courts always prioritize the cold, hard biological truth, even if it might turn a child's world upside down? Or is that old legal shield, the idea of protecting a child's legitimacy, so important that we should keep it, no matter what science says? Let me know what you think. Drop your take in the comments. Man, that was a complicated one. But understanding how our legal system evolves with science is absolutely crucial. To stay sharp and join a community that values truth over noise, make sure you are subscribed to KanoonPlus. Thank you for taking this deep dive with me. I will see you in the next one.
Friends, don't forget to share your views in the comment box and subscribe to KanoonPlus channel.